but I memorized it. And I hid his book down under my boxes, under everything. And I got up there and, across it, "Isn't it true, doctor?" And I then spewed this paragraph at him. And he looked at me and said, "That's nonsense, Mr. Rawls." I said, "Well, are you sure?" And I repeated it. And he kind of reared back in his chair. "Well," and then, of course, I pulled the book out. "Now, doctor, you wrote this textbook." And at that point, I could have suggested to the guy that he'd bombed Pearl Harbor, and he probably would have said, "Yeah, I did. I'm sorry."
This is RVA Trial Lawyers, Virginia's trial lawyer podcast, hosted by Sharif Gray and Niall Abuzaki.
All right, we're back, and we've got Brewster Rawls joining us today, one of the area's foremost medical malpractice attorneys. Brewster, thanks for joining us. Go ahead and introduce yourself to our listeners.
Well, I'm glad to be here, and I appreciate you calling me foremost. I am one of those rare commodities as a lawyer, and that is I love practicing law. I've loved it from day one. I love being a trial lawyer. You can make whatever lawyer jokes you like, but I like doing it. I've been a medical malpractice lawyer for 35 years. I stumbled into it. I was a defense lawyer for many years, and about 5-6 years ago became a full-time plaintiff's lawyer. Been doing federal tort claims cases for a good while before that. I have no science background. I always used to joke as a defense lawyer that if the doctors could see the paucity of science cases I had and the grades I received and the ones that I took, they would have asked their insurance companies for another lawyer. Be that as it may, I loved it. It was a great business. I've loved it all along. Every one of these cases is different, and when you can sit there and learn about disseminated intravascular coagulopathy and explain it to a Hampton jury, I think that's an accomplishment. And I'm very biased, but I think being a medical malpractice lawyer is, really one of the most skilled areas of litigation that you can be in. I've cross-examined world-renowned neurosurgeons, and sometimes they've made mincemeat of me. Sometimes I've scored some points. But where else do you get the chance to do things like that except in this crazy business? I've done a lot of these cases, and I love them.
So, Brewster, how did you get into medical malpractice? What brought you to this field?
The irony is I went to law school after I got out of the Army thinking that I wanted to be a real estate lawyer. And it's a very good thing I didn't become a real estate lawyer because I couldn't proofread then, and I still can't proofread now. And that's mostly what being a real estate lawyer is. Apologies to my colleagues who do that. Coming out of law school, I got one job offer at Penn Stewart in Abingdon. It wasn't a great time on the market, and I was not exactly the greatest law student that ever lived. I went down there for Penn Stewart, which did insurance defense, great firm. I always say that what few good habits I have as a lawyer, I owe to Bill Eskridge, who was a very renowned malpractice lawyer, defense lawyer. I did a little bit of it there. I, of course, decided I liked practicing law, and I'd done pretty well. So the job market had improved, and I got offered a job at a large firm in Richmond. I went there, and by lunchtime the first day, I had decided I'd made a mistake. I'd also been worried that I wasn't smart enough to work there, and by lunchtime I was over that fear. I lasted about a year and a half there. Then I went to a firm that was kind of the premier insurance defense firm at the time that did the Cadillac malpractice defense, which was for the St. Paul Fire and Marine Insurance Company. And it was a special deal to be a St. Paul lawyer. And I went to work for them. And as they say, the rest is history. That firm broke up, which is a long story. And I kind of followed its pieces and then ended up taking that practice and growing it on my own elsewhere. And eventually we got to a firm that was pretty big, and I got tired of the defense practice, and my partners at the time were still doing it. And I'd been doing the federal tort claims cases all over the country, malpractice cases, enjoyed it thoroughly, and had thought as long as I had partners doing defense work, I would just focus my practice on that. The defense partners all disappeared in 2016 and 17, so I just said, well, let's just go full bore plaintiff, and that's what I've done, and I've had some luck with it since, and have thoroughly enjoyed it.
Being a defense medical malpractice attorney for a little over 30 years, did that make you a better plaintiff's attorney?
Absolutely. As a defense lawyer, I don't really have a good number, but I tried well over 100 of these cases, probably more like 125. When I say tried, we rolled in there, we impaneled a jury, and we started a trial. And that's just an unprecedented number in malpractice cases. A lot of busy lawyers might try 2 or 3 a year. In 2005 or 6, I tried 14 cases. There were a couple of periods in there where I did 3 trials in 5 weeks. It nearly killed me, and indeed it put me in the hospital in the middle of that, partly because I just decided that the world was full of 50-year-old men who keeled over dead, and I was having some chest pain, which I was pretty sure was stress, but about the 3rd time it occurred and I saw the particularly obnoxious lawyer on the other side stomping around, I said, do I really want to have it marked on my tombstone that I died fighting this lawyer? And I concluded no, and my cardiologist client and my MD, JD colleague at the time shipped me off to the Sentara Hospital where I got all the tests, and I was told I had about a 1% chance of dying of a heart attack in the next 5 years. But even at that, I mean, that kind of experience, I won't say I've seen everything, because I think one of the things you learn as a lawyer is that even when you've been doing it 40 years, you haven't seen it all. I will come across things all the time, and I'm like, oh, what is that? But what we do as lawyers, it's an experiential business. And as long as you stay alert and learn and are conscious of what you're doing and trying to be better, the experience is cumulative and you become a better lawyer. What happens when you've been doing it for 40 years like me is you find you don't necessarily have the stamina that you did. I couldn't try 14 cases in a year right now. No way. But the judgment that comes from that is just invaluable, and it builds up over time.
So, Brewster, you talk about doing this for 40 years and you still haven't seen it all. That being said, when you're preparing a medical malpractice case to a jury, and we often say, if you want to win jury trials, keep them simple.
100%.
Keep them simple.
100% agree.
How do you do that in medical malpractice cases? Because that's a lot more difficult than, for example, when I walk into a courtroom and prosecute a case, right? Everyone loves watching Criminal Minds or reading the next crime story. For a medical malpractice case, first, how do you simplify it? Second, how do you keep the jury engaged?
Well, it's case dependent very much. I mean, there's obviously very different areas of medicine. For example, surgery cases are relatively easy to simplify because you can break them down into mechanical terms. You can get the toys out and play. You can show the organs or the bones or whatever, where everything goes. And you can sort of understand that in a spatial sense. And so in some regards, your most complex cases involving complex surgery, you can reduce to pretty understandable bite-sized pieces. Your internal medicine cases can get just super esoteric. The example I used earlier was discussing the issue of disseminated intravascular coagulopathy, DIC. And that's about as complex as you get. But the key in any of these cases is to try to figure out what matters, what's critical to proving your case, or if you're the defense, attacking the plaintiff's case, and focus on those issues. On the plaintiff's side, you have got to figure out a way to explain to the jury that why what happened was wrong and how it harmed the patient. And frankly, some cases are such where if it's a judgment call by the doctor or something like that, it's hard to prosecute the case and take it, even if you sort of think in your heart that the patient didn't get the best care. But a lot of it boils down to just kind of having a sense of how to focus things and get them laser focused. And of course, in medical cases, what is super critical is to pick good experts. You've got to have experts who can teach. And kind of coming back to my DIC example, I brought in a fairly world-renowned hematologist. And he's up there in front of this jury, and he's explaining, he's got the whiteboard out, and he's explaining the clotting cascade. You guys might not even know what that is, but it's complex, serious medicine. And it's very funny. My surgeon client leaned over to me and goes, Brewster, this guy's really good. I never have understood this shit. To which I looked at him and said, well, please don't share that. But that's the kind of expert you need in these cases. And you just develop over time when you've done it long enough that you can discard. Every medical case has just masses of peripheral information. You've got some lab tests that might be significant. You've got some study that might be significant. but maybe they're really not. And you sort of have to paint with a broad brush, and perhaps at times you don't do full justice to the science of the case, but you've got to know when you can and when you can't. The other key in these cases, whether you're on the plaintiff side or the defense side, is you have to be prepared to attack the plaintiff's experts or the defense experts, depending on the case. You've got to be prepared to destroy them on the facts if you can. When I was a defense lawyer, probably 2/3 to 3/4 of my trial preparation was preparing to go after the other side's experts. That's what you've got to do. But frankly, that's what makes it so much fun, because it's always a different fact pattern. It's always you're learning something new. And that's why it's still so fun.
So it boils down to a battle of the experts to a certain extent.
It is.
You got to keep in mind, you have these jurors that have never heard what DSC stands for, let's say, for example, and you're trying to flush it out. You're trying to educate them. And then you got these two experts, and they're opining on the same issue, but they have different conclusions.
Yep.
How do you get the jury, as a trial attorney, to believe in your case?
First of all, your expert has to be good. And you have to, when you're dealing with the other side's expert, you have to find ways to attack their opinions. One of the most effective ways to do it, and it's always amazing to me the number of times I've seen experts do it, is where they don't have a good grasp of the records of the case. And you can look at them and say, well, isn't it true that on March 23rd, Ms. Jones' weight had not dropped? Had it go, oh, I don't know. Oh, no. And you can do that 4 or 5 times, and it can destroy their credibility. Literature can matter. Perhaps one of my greatest moments as a defense lawyer in cross-examining an expert is we had a case where my dermatologist, pathologist client had looked at a lesion and called it benign. 18 months later, it turns out to be not benign. It's melanoma. By the time we try the case in the week before Christmas, everybody thinks this lady has metastatic disease and is going to die. And the plaintiff's expert took the view that diagnosing a desmoplastic melanoma is the easiest thing in the world. I mean, a second-year resident can do it. He was an academic, and I found one of his textbooks. And of course, if you're a lawyer, you are always looking at the introductions and the conclusions, and all the data in between is indecipherable to you, so you don't really worry about it. So I found this intro to a textbook chapter where he talks about how difficult it is to diagnose these melanomas, and even skilled practitioners under the best of circumstances can't do it. Of course, it was about 25 lines long, and it was full of medicalese, if you will, but I memorized it, which I don't memorize well. It's not one of my skills, but I memorized it. And I hid his book down under my boxes, under everything. And I got up there and, and cross it. Isn't it true, doctor? And I then spewed this paragraph at him. And he looked at me and said, that's nonsense, Mr. Rawls. I said, well, are you sure? And I repeated it. And he kind of reared back in his chair. Well, and then, of course, I pulled the book out. Now, doctor, you wrote this textbook chapter, blah. And at that point, I could have suggested to the guy that he'd bombed Pearl Harbor, and he probably would have said, yeah, I did. I'm sorry. And that's something that's really very mundane if you think about it. But it's a basic lawyer skill of just trying to find some weakness. And, of course, you have to know what the guy's written, know what he said, have the data. You have to understand it. And you find something like that, that's just dynamite impeachment.
Well, you found the lie, right?
You could call it that. I think you forget what you write sometimes, and you look at this, and I think he looked at a case like that and said, how could any idiot have missed this lesion?
Now, when I talk about this concept often, this idea that the jury is looking for who they can trust. The jury assumes, and rightfully so, that the lawyers on both sides know more about the case than they do.
Sure.
And they're looking for a guide. And it sounds like in that example, you were able to very clearly show that this expert witness is not one that they should trust.
Yeah. I will tell you something about juries, having done a lot of them in civil matters. The joke is always go down to Walmart, count off 7 people. That's a jury. And it's true. And sometimes it's an appealing 7 people. Sometimes it's a scary 7 people. But the reason that juries usually get it right is I think that it's common sense. And I think juries typically have a pretty good sense of who's trying to sell them something. who's trying to feed them a line. They may not understand the nuances of the medicine. They may not get all of the facts, but they can kind of smell collectively who's really trying to get over on them. They understand that. And that's why I think most juries, most of the time, come to the right result. I've never been a criminal lawyer, never tried a criminal case. I was on the court-appointed list for about a year and a half and was not talented at all. But I think when you look at juries of any sort, most of them, they come to the right result. And even some of the ones you see publicized all over the press, when I look at it as a trial lawyer, I can look at that O.J. Simpson. I can look at that case in Wisconsin, Rittenhouse, and I can say, I understand why that jury did what they did. And yeah, you can look at O.J. was probably guilty, but you can make a pretty good argument that the state of California didn't do a good job of proving he was guilty. And situations like that, and I think sometimes lay people can't really grasp that very well. But if you've tried cases, you understand it, that juries look at that and say, no, somebody's trying to sell us something they shouldn't be trying to sell us.
It's all about building credibility.
Absolutely.
It's all about building credibility with a trier of fact.
And simplifying it, which is what we talked about. One thing I wanted to mention, Brewster, in 2020 and 2021, you had the largest jury verdicts in Virginia.
I did.
A $10 million verdict and a $6.5 million verdict. When I was reading about them, the thing that stood out to me was that in both of those cases, you came in as trial counsel and you deliberately chose to pare down the case, to make it simpler, to get rid of defendants in some situations, to change the focus so it was much cleaner. Why is that?
I think a lot of lawyers are so fearful that they will miss something that they include huge volumes of information, theories, and themes that they don't need to have. I am a minimalist. I've always been a minimalist. I can take a 10-minute deposition pretty easily. A couple of things. One is if you have 3 claims, one's really good, one's okay, one's kind of weak. A lot of lawyers tend to think that the strong claim pulls up the weaker ones. I disagree. It's the other way around. You dilute your good claims, you dilute your good themes. So if you've got something that you don't have to have, get rid of it. You don't have to have it. I'll give you an example. In the case in Petersburg, which was the $10 million case, we had defendants who, they probably had liability, but they were just peripheral to it. Got rid of them. We could have made a claim for economic damages in the death of this woman, but when you looked at the total facts of the case, what it was really about was that they killed the mother. And that $300,000 or $400,000 number that we could come up with at best wasn't going to help it, and at worst could have anchored a jury verdict much lower than it did. So it kind of comes back to you got to present something to the jury that's simple and makes sense. I would also sit here and tell you that when you're on the plaintiff's side, one of the things you want to do is give the other side as little to talk about as they can. And that's why, for example, of leaving out the economic damages or the medical expenses, when you raise that, that gives them things they can pick out. Well, this what shouldn't have been included, or maybe she wouldn't have worked this long. It's an element that can confuse a jury, and you have to add, is it really worth it? And if it's not, cut it loose. But what about, but I just cut it loose, be done with it. Part of being a trial lawyer is you have to have the ability to make judgment calls. And if you're trying to do everything by a checklist and never leave anything out and cover every conceivable base, you will end up spending 3 times longer than you need to and present something that's indecipherable to people.
Brewster, it's interesting that you say about being a minimalist and just keeping it simple. I recently had a murder jury, and prepping for the jury, I thought my strongest witness was a historical cell data expert. And I spent days and days and days preparing him to testify. 7 witnesses in, he's up next. We take a break. He's like, am I up next? And he was scheduled to be up next. And I was like, what is he going to add? And then I was like, the only thing he's going to do, this case has been simple. The jury's nodding. They're listening. He's going to make the case a bit more difficult for them. I looked at him. I was like, Joe, you're not testifying. He's like, what? I was like, you're not testifying. And another attorney goes, no, what are you doing? I was like, he's not testifying. And we continued on and through our other 8 witnesses. And it was a case where we had an eyewitness to the murder that died a few weeks prior to the trial. So we had to rebuild. The jury came back guilty within less than 2 hours on first degree. And after the fact, I was like, now, how much would have a historical cell data expert have helped? And I don't think he would have helped at all. He would have made it a bit more difficult for the case, and he would have given the defense something to put holes in.
But I think it also comes back that what you're saying there is exactly the matter of a judgment call that based on your experience, you made that call and it was a reasonable one at the time. And even if you had not prevailed, it still would have been the right call, although people could second guess you then.
Exactly.
But I think if you can't do that, if you can't sort of look at, trials are dynamic, and if you can't look at it and make judgment calls in the middle of it and not panic and, what do I do? Then you're probably in the wrong business.
Yeah, they certainly don't go as planned.
No.
They never do, right? But we do spend a lot of time preparing for them. But there's something about just being in that courtroom and being in the moment and truly being there. I actually have become a proponent of not taking notes. I listen, and it took me a while to get over that. But I've come to realize that if you're taking notes, you're not really there. I'm sure you guys can relate, but there's times you'll probably look over and you'll see the other attorney who's getting ready to cross-examine the witness, and you'll see that line down the middle of the piece of paper, and it's them writing what's happening on direct and what they're going to do in response on cross. And when I see that, I'm like, yikes, just listen. Well, it's great if I'm on the other side because it means they're not paying attention. But really being there and listening and knowing what you're trying to achieve is everything.
I would tell you that when I try a case, any witness on direct, there's one page with probably 10 things written on it at most, one page. When people have worked for young lawyers and they go up there, if I see them checking off, I want to go up there and just slap their hand, like, no, take their pen away from them. Because you're absolutely right. You've got to listen to witnesses. And it's not just what they say, it's how they say it. It's how they squirm a bit when they say it or don't squirm. And you've got to listen. And if you don't have that ability to listen to the witness, then you're missing something. And if you're too busy trying to be the court reporter, I'm not to the advanced stage that I can't take notes. But I will tell you, when I'm listening, preparing for cross at trial, I only make a note about something that I think is significant that I might want to cross. And usually it's 3 words. Stuff that matters is the only thing I'm going to write down on my list. And that's where you go from. But you're absolutely right. You have to listen. And if you don't listen, and I've seen many cases where lawyers who are smart people, but they haven't listened, and they go there, they've got their checklist and they've got their notes that they prepared very meticulously, but it doesn't fit what was happening there. And so it doesn't work. It's a dynamic situation. It's also knowing when to shut up. I watched a trial earlier this week. I'd actually gone down to Chesterfield because I wanted to see a witness who I've used a number of times. I've actually had him against me. Turns out he wasn't there, but the defense witness that was put on was terrible. And the plaintiff's lawyer got up and he made a mess of him. It was beautiful, but he then shut up. He sat down and shut up. He didn't beat on the guy. He didn't keep kicking him. He knew when to sit down and be quiet. And that's a skill too you got to have.
Brewster, you've had over 100 jury trials. That's unheard of nowadays for young attorneys. I don't know if that's in the cards anymore. And so some of the things that you're talking about, I'm sure have been developed and refined over the last 30, 40 years in the courtroom, on your feet, trying cases. What are your thoughts about young lawyers trying to find that experience, get comfortable in a courtroom?
That's really hard. When I started at Penn Stewart, it was in the days when insurance companies still hired people by the hour to do a good job and evaluate cases, send them the reports, do the discovery, evaluate the case, try the case if need be. And in the first 2.5 years of practice when I was in Abingdon, Virginia, I tried 20 jury trials, roughly, plus or minus. Now, my joke is that the aggregate value of those civil jury trials was probably not $100,000, but they were my cases. And I went in there and I tried them. I was first chair. I'm the one who had to sit there and make the decisions and do it. And that was just the most incredible training that I could have to be a civil lawyer. Those kind of practices sadly don't exist anymore. They just don't exist. I think being a prosecutor is probably as close as you get to it, but the skills of a good prosecutor are different than the skills of a good civil defense lawyer. Prosecutors have wonderful ability to think on their feet, act quickly, but a lot of what being on the civil side is very boring behind the scenes, putting the pieces together, learning the medicine of a case, if you will. And some of that is alien to people who come out of the criminal side of it. They can learn it. I've seen some people become very effective lawyers at that. But that kind of pool of low-level insurance defense, and of course I was trying to cases against plaintiffs' lawyers who were also doing equally low-level cases to me. I just don't think those really exist anymore. I don't think that they're tried like they used to be. And I think nationally the number of jury trials is way down. And I think the number of jury trials in littler cases where people get experience is really low.
Brewster, you've had many cases throughout your career. We're talking over 100 jury trials, and you're still going strong. What case doesn't have to define your career, but stands out and sticks with you as you sit here?
I'll give you two examples. One is a good one, one is a bad one. Let me give you the bad one first. We had a case years ago where a poor guy ends up with a maxillary sinus cancer, a bad disease. Basically, you take out about half your face to treat it. And the allegation was that my doctor had missed it early on. We had solid reviews from some of the best people in the world. The plaintiff's case, as it went along, got weaker and weaker. And finally, about a month before trial, the plaintiff's lawyer calls me up and says, "Brewster, will you arbitrate the case?" And I said, well, let me talk to the carrier. And I called the carrier up and I said, guys, this is an ugly, bad case. Arbitrate it. You probably get hit for $200,000 or $300,000. Let's get rid of it. And he hemmed and hawed and all that. No, try it, Brewster. There were some issues in the case and big damages. So we go try it. And the trial couldn't really have gone better for us. It was a great trial. Just beat up their witnesses. Some of them, they just kind of pieced together some depositions and things like that. Jury goes out, jury comes back in, and it was done in Newport News, and they first hand it to the judge who reads the verdict, and he looks at it, and he gets a funny look on his face, and he says, well, verdict is correct as to form. Hands it to the clerk to read, and the clerk, read the jury on the issues joined, find in favor of the plaintiff and award $25 million. For 14 years, I held the record as a defense lawyer for the biggest verdict against him in Virginia. But it's an example of how you can have everything go right. It can all just be brilliant, and that jury had a different mind. The other example would also be on the defense side, where I had a case where a lady was pregnant. She'd had a previous classical C-section, which meant she needed a C-section again. She goes in, she's visiting her OBs weekly toward the end of the pregnancy. And they look at her and say, well, you're good. Come back next Tuesday and we'll deliver you. And what happened on Saturday, she ruptured. It nearly killed her, but she survived, but the baby was dead. Autopsy of the baby, perfectly normal baby boy. They could have delivered him. He would have been healthy, fine. So the only issue in the trial was whether these doctors, when they had looked at her the week before, the 2 weeks before that, had ignored the warning signs of it. And because if they delivered her a week early, she'd have had the baby. The baby would have been healthy. That's a single issue in the case. Very, very competent plaintiff's lawyer on the other side. Very good experts he had. My doctor was a good doctor, but she was a little wacky. She refused to consent to settle. I tried to get her to settle the case. And we tried that case. That was the one that scared me the most. And we ultimately won, I think partly because I was able to very effectively cross-examine their witnesses on it. I also ended up having a surprisingly good witness myself, although he was Italian and his English was not entirely great, but the jury just loved him. I'll give you another example of a trial which is humorous. You'll laugh. I had a case down in Southside, Virginia, where it was alleged that the doctor had missed a heart attack, a heart condition, in a patient who died in the hospital. Well, I couldn't find any expert to support the case. My client was the only person who determined that the EKG which was done was anything close to normal. So I had no experts. And literally the week before trial, I was in the doctor's office flinging F-bombs at him, telling him he was that stupid he needed to consent. And he said no. So we get to about a day or two before trial, and I say, okay, how do I try this case? I don't have any experts. What am I going to do? So I thought, let's pretend I don't need experts. And I went in, and it was one of the most fun cases I ever tried in my life. So I get in the opening statement. I say, this plaintiff's lawyer, he's going to bring you a bunch of paid people, paid to be here. He's paid them. And this poor professor from Johns Hopkins gets on the stand, and I get up there. My first question is, doctor, you got a check for $7,500 to be there. It was like a movie. I turned to look at the jury, say, $7,500. And the poor guy's like, well, yeah. We won that case. We got a defense verdict. And of course, as we were walking out of the courtroom, my client looked at me and said, I told you it was a stupid case. That's what makes this business fun.
So, Brewster, what does a typical day look like for you now?
Today was a pretty good example. I looked at 2 potential cases. Probably took about an hour to look at the review memos and some of the records on it to make my recommendation as to whether we take the case or not. I looked at one we reviewed earlier in the week that dealt with an interesting and esoteric question of Alabama law and damages. It's a federal tort claims case, obviously. So I was actually looking at Alabama law a little bit earlier today, which is quite funky, by the way. I did that. I revised a complaint in the case we're getting ready to file probably next week, things like that, and answering the email traffic. And we just had a lawyer leave us to go to work for a big firm. So I was going to spend some time redistributing his work and trying to figure out what we needed to do to make sure that was covered and things like that. I mean, that's kind of a typical day. Dealt with a problem call from a client who was unhappy over nothing, frankly, but I talked to her and got her calmed down. Talked about settlement strategy in another case we have coming up for trial in October where we're making some progress on it, and reviewed some pleadings that had come in. That's a fairly typical day.
When it comes time to trial, how does that change? Do you at some point block off your schedule for a week or so? You're not just the trial lawyer there. You're also running the day-to-day operations, right?
It's small enough that it runs itself fairly well, and I've got a great office manager and really good people working there. Ideally, you try to take the week before trial and just spend it focusing on things. That's what I try to do if you can. What I've learned over time, however, is that if you can actually start that process about a month before trial, it's better. You kind of spend a few days, 30 days out, looking at something pretty intensely, put it aside, go do other stuff, come back, look at it again. I'll give you an example. I had a case. It's one that came to me in December of last year. It was fully worked up. Plaintiff's lawyer had to get out of it. I agreed to take the case. It had some warts on it, but the guy had end-stage prostate cancer. If we didn't get it tried in April, that was going to be tough. He was going to be dead if we put it off for a year. But the problem is it was the Monday after Easter, which is a big holiday in my house. And the week before that, not the week of Easter, not Holy Week, but the week before that, I was on a mission trip in Utah. So this kind of screws up your trial preparation because I've got to cook lamb and everything on Easter and things like that. So what I did about 3 weeks out, I took 4 days or 5 days out of a week, and I just said, this is my trial prep week. And I sat down and prepped for the case then just as if I were going to try it the following Monday. And it was remarkable how when I came around to the next week, the week before Easter, when I got back from Utah, kind of looked at pieces, but you know you're ready for a case when you sort of think of, you're just looking at the same sort of flipping through things and you're thinking the same things over and over again. And I thought I was beautifully prepared, and I was. I'd like to tell you we won the case. We didn't. But that was an interesting experiment in trial preparation because I think you've got to give yourself a little bit of that quiet time. When I was a defense lawyer trying these all over God's creation back to back, I had really good people working with me who would put the pieces together, and then I would come in and kind of connect it all up at the last minute. But that's a hard way to do it. And you've got to have really, really good people that you can just absolutely 100% trust. And even then, sometimes the stuff they do isn't what you would do, but it's got to be good enough and you can't fuss about it. And I was very lucky as a defense lawyer because I had some super good people work with me at times that we worked on cases together where I could walk in, pick up the file on a Thursday and try it on Monday.
Brewster, it's very clear sitting across the table from you and having followed you now for a little over a year or so that you really love what you do.
I do.
Well, what is it about trial work?
I think it sort of satisfies my intellectual curiosity. Interestingly, I'm not an athlete. I've never been an athlete. I frankly don't care about sports at all. But that's not to say I'm not a very competitive guy. And I think it is a great outlet for that. I like the challenge of winning. And no, I don't like losing cases, but you can't have the good without the bad. And I love that sort of ramped up challenge of getting a good result and accomplishing something. And I think most of us go to law school with some sense that we're there to help people. And I like that. What I do now and what I've done as a federal tort claims lawyer, as a plaintiff's lawyer, even what I did as a defense lawyer, you're helping somebody. And I think there's a huge satisfaction for that. And it's a skill that being a good trial lawyer is a skill that not many have. And it's a super skill that I think is underappreciated. But like anything else, to be good at it is just its own satisfaction.
What makes a good trial lawyer?
I think once you get past the basic issues of fundamental intelligence, education, things like that, the two biggest issues that make somebody a really good trial attorney are a genuine fearlessness, that you go there, you just give it your best shot, and you're not worried about what anybody thinks. You give it your best shot, you do a good job. But also curiosity, that you're looking at cases, you're looking at situations, you're looking at scenarios, and you're trying to kind of put those pieces together and look at them a little differently, think of them a little creatively. And I would say creativity is another thing that goes with really good trial lawyers. You have to have that spark of curiosity, of creativity, but it has to be coupled with an utter fearlessness.
Brewster, there's a lot of young lawyers who listen to this podcast and are probably sitting there thinking, I want to be Brewster Rawls, or I want to be a trial lawyer. What do I do? And we talked about this earlier. Just the opportunities don't seem to really be out there. But if you were graduating law school today, or if you were advising a young law student, what's some advice you'd give them if they said, Brewster, I want to be a trial lawyer?
I think there's two routes you could do. I think one is you could go to work for the very best lawyers you can find and hope that you can get some experience, a lot of it more or less by osmosis. But I think what I would really probably tell somebody right now is to go be a prosecutor so that you get that experience of being able to stand up and think on your feet. If they wanted to be a civil trial lawyer, I'd say probably don't do it more than 2 or 3 years, but do that and then try to go at the very best civil firm you can find. It's not an optimal route to do it. I was very lucky, but I was at the end of an era. But I think that's probably the most logical route to do it. Now, you go to a big law firm, you'll get exposed to a lot of stuff, but you won't ever really do the sort of things that you need to be able to do to try cases. And trying cases is one that you've got to do it. You can read about it. You can understand the theory of it. You can prepare in great detail for ones, but kind of coming back, it's an experiential business. And you build on experience, and that judgment comes from experience. Usually bad experience is where your judgment comes from. But you've got to have that. And if you don't have it, that's tough. And think about it. If you were being sued for malpractice, would you want to be somebody's first jury trial? Just do whatever you can to get that experience. And I would also tell young lawyers to be pretty aggressive about grabbing experience. One of the advice I give to people in my office is I can never remember whether it's Dillon's law or the opposite of Dillon's law. It's like the local government law where in some places the government can't do anything except that which is expressly permitted by the state, and in other ones, unless it's prohibited, you can do it. Well, I'm of the view that unless I've told you can't do something, within broad bounds of reason, you can do it. And I'd much rather have a young lawyer that I have to reel in every now and then, shaking my head, than have somebody I've got to push out the door and give them the boot to make them swim off the pier. And I think that was the wonderful thing about my early experience at Penn Stewart. They sort of dropped you off the pier, and they kind of had a lifeline there for you, but you were expected to swim, and I did.
Brewster, you're familiar with Rick Friedman, of course, probably the plaintiff attorney for decades now, right?
Yeah.
He has a number of books, and one of them is called On Becoming a Trial Lawyer. And there's a line in there that I remember reading, but I didn't fully appreciate until I learned the lesson the hard way. The line was, early in your career, trade money for experience. The money will ultimately come if you find something that you enjoy doing and you end up doing it well. And it sounds like that's the advice that you're given, right?
Absolutely. I think the first 5 years you work as a lawyer are just defining for you. And I kind of look at it like I had a residency at Penn Stewart, trying those cases, handling stuff in the coal fields of Southwest Virginia, which is wild country, by the way. And then I went to McGuire Woods. And the interesting thing about McGuire Woods, I didn't try a single jury trial while I was there, but I was exposed to things in doing that I would never be exposed to anywhere else. And for that, I'm grateful for the experience. And when I came out of that, by the time I got to Browder Russell 5 years out of law school, I was pretty well trained as a lawyer, which is one reason I was able to step immediately into those malpractice cases. It was also, I was kind of a bullheaded, confident guy, and I just took them and ran with them and didn't ask permission. But I was also almost inadvertently beautifully trained as a lawyer by the time I got there.
I remember a couple years ago, I had this quarter-life crisis, if that's what you want to call it. I'm 34, so it's a little past quarter-life crisis. But I remember sitting there thinking, I think I even talked to my parents, there aren't many trials anymore. And I went to law school because I wanted to be a trial lawyer. That's all I've wanted to do. Try cases, and learn from the best. And I'm just not seeing it. And then at one point I made the decision, screw it. I'm just going to double down and commit to being a trial lawyer. Even if it's not happening as often as it was, there'll always be a need, whether that's true or not. And I'm just going to double down and do everything I can to learn to be the best trial lawyer I can be. And hopefully there will be work for me in the future. What are your thoughts about that, Brewster? And specifically, do you think there will always be a need for the person to go and stand up in a courtroom?
Well, I'm 68 almost, so I think in my lifetime that's certainly going to be true. But that's not saying much. Hopefully I'll live a while. But yes, I do. I think there will always be a need for people who can actually go in and try a case. I think we are always going to have some means of adjudicating it. I don't see the jury system in our country going away. I think expense and other factors have made it awkward to use in civil cases, but I'd be hard-pressed to see it disappear, that we switch to some sort of pure administrative law model. But even if we did, you're still going to need advocates. You still need to have people who can stand up and think on their feet, who can examine witnesses, and who can process evidence and present it to a trier of fact, whether it's a jury or a panel of judges or a single judge. All of those are skills you've got to have. And I think you learn to try cases, you learn to be a trial lawyer by being a trial lawyer. You don't learn it by reading books. You don't learn it by being second chair to somebody, although you'll learn a lot doing that. You learn it by being the person doing it. So I commend you. I think that's a smart move to make. And the comment about the money, it may be tough for you for a couple of years, maybe 3 or 4, maybe 5. But I think if you learn those skills, there are just not that many people who can do it.
And I think maybe going forward, the pool of people who can do it is going to get smaller. Maybe the skill of a trial will become more lucrative.
It could. And I think if you look at a lot of the larger firms, there are people in there who at this point have probably never tried a jury trial, and they're their litigation department. But have they ever really tried a jury trial? Not many, if any. Even among the big plaintiffs firms where you have that kind of powerful advertising, you have people who don't really have that kind of base of extensive trial experience. And part of the problem is if you're in a good and well-established plaintiffs firm, you pick good cases and you have the resources to work them up well. And if you pick good cases and you work them up well, then you're not going to try very many of them. You're just not. And that's a good thing financially, but it's not a good thing in terms of giving people trial experience because there's just not that pool of little cases to deal with.
What I'm hearing, Brewster, it's like, go find the grunt work, right? If you're coming out of law school, go find the job that's going to make you try all those tiny little cases because you got to learn. You got to get on your feet. You got to get comfortable.
Exactly. I mean, but you, of course, have to balance it against the client interest. And if you're a civil lawyer and you've got a decent settlement offer, I can't just say, no, turn that down because I want to try that case. There's that factor to consider too.
Course.
But what I would tell somebody like you is if you've got some case where client won't settle it, your colleague doesn't want to try it, say, I'll take that case. And you know what? You'll lose most of them probably, but you'll win enough and you'll get the experience that it'll matter.
Great experience and a great reputation inevitably is going to lend itself to more settlements. Have you seen that throughout your career?
I'd like to think that my name alone gives cases value. The reality is, if it does, it's not much. Cases are driven by their facts. And if you've got a case with good and powerful facts and you've worked it up well, I think the fact that Brewster Rawls is on the other side, it may have some impact, but I can't really discern that it does. And I think when I start thinking like that, I'm going to get in trouble. I will tell you one thing that you need to have a reputation for, however, which I always have, good or bad. You have to be known as somebody who is willing to try a case.
We talk about that often. You don't want to be known as the settlement attorney.
Yeah. There are lots of particularly defense lawyers out there in the world who talk tough, and they're going to go and they're going to make life difficult for you. They're going to take every deposition. They're going to do everything they can. And then the month before trial, let's settle it. I've got consent to settle. And my joke is there are people that if you gave them a choice between trying a case and cutting off their finger, the questions would be, how sharp is the knife and how long will it hurt?
Brewster, reading about you and listening to you the last 40-some minutes, what comes out is humility. For someone who's done over 100 trials and has the 2 largest medical malpractice verdicts in the Commonwealth of Virginia, there's a lot of humility to Brewster Rawls. How important is that?
Vital. Because what's going to happen to you as a lawyer, you are going to lose cases, and it hurts. It's painful. Anyone who tells you it's not personal, it is. It's a personal rejection when you lose something, when something goes wrong. If you don't have a humility to you about that and knowing that, yeah, today was great, but tomorrow can be a disaster, you'll go crazy in this business. You shouldn't be in it. And I try. Believe me, I have plenty of ego. But I think you do have to have sort of a sense that, you know, it's not about me. It's about the client. You can do everything right and sometimes have disasters, and you just give it your best shot and go. And if it works, that's great. If it doesn't, all you can do is dust yourself off and move on to the next fight. And it hurts. The case I lost in April, that hurt.
Brewster, is retirement on the horizon?
You know, no. I'm having fun. I'm healthy. I still like doing this, and I'm still reasonably energetic. There are some things I don't do anymore. Don't ask me to draft discovery responses. I won't do it. I'll find somebody else to do it. But I still like what I'm doing, so no. As long as I can do it and I'm healthy, I'll stay at it.
Well, Brewster, it's really been a privilege having you here. And
well, thank you.
I know you may not think that your name adds value to cases, but it adds value to our podcast.
Well, I'm happy to be here. Thank you for having me. Thank you for having me.
It's been a pleasure. Thank you, Brewster, and I look forward to staying in touch with you.
All right. Take care. Thank you.
Thank you for listening to this episode of RVA Trial Lawyers, Virginia's trial lawyer podcast. For more episodes, check out rvatriallawyers.com.